Hi guys, welcome to Manoeuvre, and this is Advocate Nisha Lotia, and my today's session is about the most expected questions in the MH Law CET 3 years entrance exam, which is going to be held on 1st of June for the legal aptitude section. Guys, almost just 25 days are left for the exams, and I'm sure that this video will surely boost up your preparations and thereby even your scores. In this section, I have mentioned the topics which were asked in the 5 years exams, which was recently held on 21st of April 2019. So the recent paper analysis will help you to understand what types of questions you will encounter on your D-Day. Legal aptitude section I can rate was easy to moderate section. It wasn't hard. Okay, so it was easy to moderate, which you could actually score up. Principles were based on topics like Contract Act, Tort Law, Indian Penal Code and Indian Constitution. Over here in this video, I have discussed only the topics, but if in case you want a detailed explanation, you can join our online classroom programs at our Borivali or DADAR centers, whichever is approachable to you. And if you are not Mumbai based, you don't have to worry. You can join our online programs, and I have mentioned the details in the description. So guys, as always, I can say contract was one of the most dominant area in the examinations. Questions were based on the topics like offers and proposals. The questions were absolutely principles and facts based. Whether the particular offer will amount to a valid offer or will it amount to a contract, the questions were based on those lines. So offer is a topic which you can't ignore, is a must do topic. Even the acceptance, the two valid ingredients of acceptance, which is the communication and the acceptance has to be the mirror image. These kinds of principles were incorporated in the exams. Now the lapse of offer. This is one of the topics which you can't just ignore. Lapse of offer, how a offer gets lapsed by its own, and by with a considered timing line. All those topics were very important. Now when it comes to a consideration, it goes without saying that the consideration has to be of course lawful, but the question was posed on the quantum of consideration. Like the quantum of consideration is not at all important till the time some quantum is there. So the question was based on that principle. Then illegal agreement. There is a lot of difference between agreement and contract, and in that also illegal agreement is entirely a different concept. The question was based on this principle also. Consensus ad idem. This is one of the Latin maxims which means meeting of common minds, So here I have explained this very well in my videos, and even I do this with lots of example in my classroom lectures. So in this consensus ad idem, there has to be common minds between the people entering into the contract. So a question was based on this principle also. Then there is a very thin line between the fraud and misrepresentation. So this concept is very important. In the 5 years paper, there was a question based on misrepresentation. So you can expect a question based on fraud for your 3 years. Void and voidable contracts. Students are always confused with this topic, so it is one of the most favorite topics for the examiners, the paper setters. Void and voidable contracts are two entire different things. Void contract does not mean illegal contract. Void is not an illegal contract. It means during the time of formation it was absolutely legal, but later on subsequent impossibilities has come up so that you cannot perform the contract. That is the definition of a void contract. So there was a question from the void contract and a voidable contract. A particular fact was given, both the definitions were given and a particular fact was given, and you were supposed to determining which whether the contract was a void or a voidable contract. Then the topic surety, creditor and debtor. There was a principle based on the surety, whereby the surety's liability was coextensive. So you can expect this time the questions from bailment or pledge or contingent contract. Okay, so these all are the topics. In short, I want to just mention over here, these are important topics. You can expect at least 4 to 5 marks from here, these topics. Also a must do one. Contract is a thing you just can't ignore. Please clear all your concepts about the Contract Act. It is a very dominant part of the entrance exam. Okay, now moving towards to my other topic, that is law of torts. Law of torts is very important. There are very few topics in torts. So I advise that you should, not leave a single topic. You should, your concepts has to clear with the whole curriculum mentioned. In the torts. It is very important. The first one, the topic was injuria sine damnum, means injury without damnum, without damages. Okay, where there is an injury without damages, then also you get the compensation. I have explained very well in my online program also and in the classroom lectures also. So damnum sine injuria, again I have explained this very well with lots of examples. You can always take advantage of my lectures for here. So these are the must do topics again. Okay, in defenses there are, tort is a civil wrong. Okay, so there is always the defenses available. Why it has happened? It has happened out of accident which was not foreseeable, or where there is a, if you have this is a consent is a good defense. If you have consented for a certain thing, then you cannot claim for the same. For example, I'll give you the same facts were asked in the paper, that if a guy is going to watch an IPL match, so when he buys a ticket, when he brings the ticket, he always consents for some of the injury, like if a ball hits his head. So if a ball hits his head, can he sue the cricketers? He cannot sue. Why? Because in a way it is an implied consent when he is bringing the ticket. So over here, for a layman there might be a problem, but for according to a lawyer it is a implied consent. Then necessity knows no law. Okay, so these kinds of topics are very important, which were covered under torts. Then vicarious liability. What is a vicarious liability? Normally a person is always liable for his or her own wrongs, but in vicarious liability you are liable for the wrongs of others. So this is the whole concept of vicarious liability, and I guess almost every year you get a question from vicarious liability. So again, a must do topic. Next is the strict liability. In a 5 years paper, strict liability was covered. So you can expect even the absolute liability for the 3 years. Now strict liability is somewhere where you are dealing with hazardous substances. So if that hazardous substances escapes from your vicinity and creates some mischief, then the strict liability rule is applied. There are certain exceptions to strict liability, but for absolute liability there are no exceptions. Cases like Rylance versus Fletcher, these are one of the most important case laws which you have to study for strict liability. Nuisance does not require intention. Intention is immaterial when it comes to nuisance. If a normal layman feels that this thing is annoying to him or irritating to him, it will amount to nuisance. So nuisance was one of the most important topic. There are two types of nuisance, which was a private nuisance and a public nuisance. So you can expect a topic from nuisance. Then they have introduced this one, the negligence. Nowadays they name it as professional negligence, where it is a duty of a professional to take care, but if he does not follow his duty, then there can be a charge of professional negligence. But one of the most important ingredient in professional negligence is about that there has to be some harm, there has to be some damage out of this professional negligence, then only you will be getting compensation. Compensation is a main thing in tort, because here there are no punishments. Here we get compensation in civil wrongs. So these are the must do topics. I have explained them very well on in my online programs, and even we are conducting the classroom lectures. If you guys are you can attend it. Okay, so this was about law of torts. I again mentioned law of torts is very important when it comes to the entrance exam, a must do topic. Now let's move towards the Indian Penal Code. Indian Penal Code, like, it covers the criminal side. The different offenses, and thereby the defenses and the punishments are mentioned under the Indian Penal Code. So general exceptions to the crime is, these are kind of defenses. Mistake of facts. If a person is committing certain act and whereby there is a mistake of fact, it will always be excusable. On the other hand, mistake of law, mistake of law is never ever excusable. So this can never be a defense. Only mistake of facts can be a defense. And that also depends upon the jury. He will decide as per the case. Then communication. There was a question imposed on communication. Communication whereby you are communicating to somebody in good faith. In good faith. For example, a doctor communicating to his patient that he requires to undergo a bypass, and listening to it. If if there is some harm to the patient, then the doctor is not held liable, because he is doing his duty out of good faith. He is communicating. So communication is always a good defense. There are so many other defenses, but these two were asked in the examination, so you can always prepare on the lines of other defenses. Now there are various kinds of offenses. Offenses are always asked in the pattern, where they will give you, in principles, they will give you at least offense 2 to 3 definitions of offenses, and as per the facts you have to see which offense has to be applied. So theft is what? There is no consent available. There is no consent available, so that is theft. For a layman, every crime is chori, but not for a lawyer. Okay, so every crime is defined in a different way, whereby the different quantum of punishment can be established. So there are different offenses. There are just few which were asked here. Theft, criminal misappropriation, whereby how it is different from theft. In theft, from starting itself that you're gonna do a wrong thing, but in criminal misappropriation, it is not when the act is starting, it is not starting with a criminal mind, okay, basically. But later on, when you come to know that whatever I am doing is wrong, or wherever the offender is doing is wrong, thereby he converts the property to his own use, then only it will fall into the category of a criminal misappropriation. Cheating, it goes without saying that it is one of the important ingredients, because all the students can relate to it. Next is the wrongful restraint. There is another thing called as wrongful confinement. You have to distinguish between the two, what is wrongful restraint and what is wrongful confinement. So question was based on wrongful restraint, so you can expect a question from wrongful confinement. Abetment, the simple meaning of abetment is to aid somebody, to help somebody. Abetment in itself is a crime. Okay, so there was a question based on abetment. Culpable homicide amounting to murder. You can always expect a question either from culpable homicide amounting to murder or a culpable homicide not amounting to murder. Okay, over culpable homicide amounting to murder gives you an hang till death punishment, and in culpable homicide not amounting to murder, you won't be getting such rigorous punishment. Okay. So these were the topics which were covered for your 5 years. So you have to now boost up your preparations on these lines. You will be having questions based on offenses and defenses. So these are some of the offenses, and there are many more, and for that you can view my online videos or my classroom lectures. Now let's go to the Indian Constitution. There were not much questions asked from Indian Constitution this time for the 5 years. There were no legal maxims also asked in this year. There was no assertion reason also asked, but it does not mean you don't prepare yourself for the same. Okay, now the question was imposed on fundamental rights, the minimum age for the Lok Sabha, and the tenure of the president. Such easy questions were imposed, so you can expect an easy paper from the Constitution side. Now miscellaneous, over here I mean to say what other acts were asked. There were question from transfer of property, which was saying once you gift a property to someone, thereafter you don't have any right over it. So a question was based on this principle. Then you can expect questions from Partnership Act and LLP also, that is Limited Liability Partnership. And intellectual property. Intellectual property covers questions like trademarks, patents, and copyrights. You can surely expect one from each of these topics in your examinations. So I hope this video will help you to understand what types of questions you will encounter, and thereby you will boost up your preparations. So guys, if you are Mumbai based, you can join me at Borivali Center by calling on this number, and you can join me at DADAR centers by calling on this number. If you are not Mumbai based, kindly join us for the online program. For this, you can call on this number, and for more information you can subscribe to our channel, and do like my video if you really think it is helpful to you, and do share this with WhatsApp and Facebook to your friends and relatives who are appearing the same. Thank you once again, and all the best.